Hello everyone. Welcome to this module on comparative constitutional law from the e-Pathshala project. My name is Triyambak Kannan. I am an advocate practicing in Chennai. I have a master's degree in law from the University of Pennsylvania and a bachelor's degree in law from the Symbiosis Law College at Pune. Over the next half an hour or so, I will be covering the topic of constitutional interpretation, the original meaning concept versus the living document concept. To begin with, what exactly is constitutional interpretation? It could be one of three things. It could be the adjudication of a question of law upon the touchstone of a constitutional principle. It could be the testing of a constitutional principle with another constitutional principle, or it could be the interpretation of a constitutional provision by which the scope and expanse of that constitutional provision is increased, or if necessary even decreased. To give examples of any of these ideas, whether a statute which provides for acquisition of property of an individual is valid or invalid based on the right of property which may be guaranteed by a constitution is the adjudication of a question of law upon the touchstone of a constitutional principle. Whether the freedom of speech and expression which may be guaranteed by a constitution is included in the right of life and personal liberty also guaranteed by a constitution is the testing of one constitutional principle with another constitutional principle. Whether the right to life and personal liberty would include rights which are not guaranteed by a statute but which ought to be guaranteed in the manner in which a state conducts itself. For example, a right to clean water or a right to a safe environment is included in the right to life and personal liberty is a question where the interpretation of the right to life and liberty is either increased or decreased. There are largely two schools of thought when it comes to a question of constitutional interpretation. The first school of thought is known as textualism or originalism, and the second school of thought is known as the living constitutional school. Textualism or originalism is often confused with also what is known as strict constructionalism or literalism. It should be clarified that all of these are not the same thing. Textualism or originalism is largely the same thing. It is also what is called as a principle of fidelity. Textualism basically contemplates interpreting the meaning of the words of the Constitution in its original sense without placing excessive reliance on what would have been the intention of the framers when they use those words. The principle of originalism is not considered as a largely acceptable means of interpretation in most countries except the United States of America. On the other hand, the living constitution doctrine contemplates that the Constitution is not a static document which was drafted many years ago and to be read only in black and white letters. The view is that the Constitution is a dynamic document that which evolves itself over a period of time, and with such evolution over a period of time its interpretation would also need to be altered keeping in mind the needs of society of that point of time. One of the most well-known jurisdictions which has largely accepted the principle of the living constitution is that of Canada. The next point of consideration is what is the necessity for constitutional interpretation. After all, the Constitution is a written document. It is something that people can read and something that most people, when they read, will be able to understand. Hence the question, what is the need for the interpretation? It's important to understand that a constitution is not the same as a statute or a law that has been drafted or enacted by a parliament. statutes enacted by Parliament can be easily drafted, easily amended, and with the same amount of ease repealed. A constitution, by contrast, is not a document that one expects to draft either regularly, amend that easily, much less repeal also with great ease. A constitution, by its nature, is expected to stand a test of time such that it goes not only from one generation to another, but over various and multiple generations. Another need for constitutional interpretation is because of the nature in which it is drafted. Most constitutions take into account two things. Firstly, it vests rights in people. Secondly, it imposes obligations either on the state or on the people. Constitutions, by its nature, have rights which are drafted usually in abstract language. Take for instance Article 21 of the Constitution of India. It says, "No person shall be deprived of his life or personal liberty except according to procedure established by law." Similarly, the Fifth Amendment of the Constitution of the United States of America, which applies to the federal or central government, says, "No person shall be deprived of life, liberty, or property without due process of law." The 14th Amendment, which applies to state governments, also says the same thing. The question now always is, what is a valid procedure established by law, or what would be a valid due process of law? The question would also be, what would be a right of life and personal liberty? Is it merely the ability to live and the ability to be free, or are there more rights which have to be read into a concept of life and liberty? This can be contrasted with, say, constitutional obligations which are written out in clear language. For example, the minimum age of a person who wants to become the president of either India or the United States of America is 35 years. There is no ambiguity as to what this would mean. A person would have to be of the age of 35 if that person wanted to be the president. Similarly, there is a clear mandate which says that in India the parliament has a term of 5 years, or as in the United States, the president has a term of 4 years. Similarly, the president of the United States of America cannot be re-elected for more than 2 consecutive terms. These are fairly clear concepts which do not leave much scope for interpretation, unlike, of course, a right or a liberty which is granted by a constitution. The manner in which, of course, courts would interpret these provisions of a constitution would depend not only on the school of thought of originalism or living constitution, but also on the needs of society and also the cultural and moral values which are placed in any society. This will be discussed more as we proceed. One of the first instances where the Indian Supreme Court had to decide between either applying a textual interpretation of the Constitution or a living constitutional principle was in a case called A.K. Gopalan versus State of Madras. The case largely challenged a provision of the Preventive Detention Act as being violative of a number of rights as guaranteed by the Indian Constitution. Mr. A.K. Gopalan's lawyer made an argument to state that even though Article 21 of the Constitution of India said that no person would be deprived of their life and personal liberty except according to procedure established by law, the word procedure established by law was the same as the concept of the due process principle which is there in the American Constitution. The Supreme Court, after due consideration, did not agree with this argument. The Supreme Court said that the framers of the Constitution had discussed both the terms procedure established by law and due process of law. The framers of the Constitution had also, in their wisdom, decided not to use the word due process of law, but only use the word procedure established by law. Keeping that in mind, the Indian Supreme Court took a clearly originalistic view, saying that they would read the words of the Constitution as written and held that procedure established by law would be any procedure which would be established by the law making body, which in this case was the Parliament. The Indian Supreme Court therefore did not find anything wrong with the provisions of the Preventive Detention Act, and Mr. Gopalan's case was therefore rejected. What Mr. Gopalan's lawyer though thought he was doing or sought to do was to read into Article 21 a principle known as procedural due process. As I had said before, the American Constitution uses the word due process of law. Procedural due process was an interpretation that was given to the due process clause, whereby courts were expected to review a procedure which was laid down by Parliament and test its validity as to whether it would be constitutionally valid and also pass the touchstone of a fundamental right as contained in a constitution. The judgment of A.K. Gopalan held the fort in the Indian judiciary for nearly 2 decades. Any and all attempts by various petitioners to read into Article 21 the principle of a due process was not accepted by the Indian Supreme Court and was consistently rejected. However, in the mid-1960s, the Supreme Court did begin reading into Article 21 rights that had not yet been given by a law made by Parliament to its citizens. One of the earlier cases is the case of Kharak Singh versus the state of Madhya Pradesh, where a right of privacy, though not guaranteed by either statute or the Constitution, was made part of Article 21. The Indian Supreme Court read in a procedural due process, and using that procedural due process said that the right to life would also include a right to live your life privately, and the privacy of your life ought to be respected by the state. This was possibly the beginning wherein the Supreme Court moved from a strict originalistic view to a more living constitutional interpretation. One of the landmark judgments of the Indian Supreme Court is that of Keshav Nanda Bharati versus State of Kerala. A 13-bench judgment, which was split down the middle 7-6, laid down a number of principles of law. One of the principles laid down though was the acceptance of the due process principle of law. The court pointed out that the due process principle of law was not merely a concept which is present in American constitutional law, but in fact it was a principle of the common law of England, from which Indian law derives a number of its principles. The court continued to say that the words procedure established by law and due process of law was nothing more than an interplay of words. By this judgment, there was an implicit overruling of the judgment of A.K. Gopalan versus State of Madras. The outright rejection of the due process principle, which had been so explicit in the Gopalan judgment, had now been watered down in the Keshav Nanda Bharati judgment. The judgment of A.K. Gopalan was finally expressly overruled in Maneka Gandhi versus the Union of India, another judgment of the Supreme Court. The Supreme Court, in fact, in this judgment categorically read into Article 21 the principle of a procedural due process. The court said that a procedure that is contemplated under Article 21 is required necessarily to be fair, just and equitable, and it cannot be simply any piece of legislation that is enacted by Parliament. With this judgment, the Supreme Court has considerably moved from its original stand of textualism to a more living constitutional stand. The court has today read into Article 21 rights that have not been expressly written either in the constitution or in statutes to its citizens, but has held that each of these rights are critical for the welfare and also for the well-being of its citizens. The Supreme Court has in fact subsequently said that after the Maneka Gandhi judgment, it is not possible even to argue that there is no due process clause in the Indian Constitution. After Maneka Gandhi's judgment, there have been a number of judgments passed by the Supreme Court wherein civil rights, which ideally ought to be given to citizens by means of a legislation of Parliament, have been vested in them through the reading of Article 21 pursuant to accepting a living constitutional interpretation. These rights would include a right against handcuffing, a right to livelihood, a right of compensation for violation of a fundamental right. All of these have come in today by the Supreme Court's adoption of a living constitutional principle. Thus, there is a clear movement of the Supreme Court from the earlier originalist stand in A.K. Gopalan versus State of Madras to the more semi-originalist stand of Karak Singh to the later living constitutional stand in the judgments of Maneka Gandhi and those that followed. Now, to understand the principle of a textualism and living constitutional principles, let us just take two examples. Suppose there is a law which states that any person who supports a group that speaks against the government is liable to be imprisoned. The question is this law valid or not? Taken in the Indian context, Article 19(1)(a) guarantees freedom of speech and expression. Article 19(2), however, imposes certain reasonable restrictions on the freedom of speech and expression. Now, if the law simply says that supporting anyone who criticizes a government is an offence, an originalist stand would be that the law requires an adherence to not criticizing the government, and therefore anyone who criticizes the government is liable to be punished. The argument would be that this is a reasonable restriction given under Article 19(2) of the Indian Constitution and therefore is not violative of Article 19(1)(a). You are free to speak, you are free to say whatever you want, but if you show support to a person who speaks against the government, you will be punished. Now, consider a situation where an individual makes a donation of money to a group that criticizes the government on any of its actions. Is the donation of money a form of support? It is a question that is required to be answered in a constitutional interpretation. The touchstone of whether this legislative principle is in line with a constitutional principle. However, a living constitutional interpretation would at the very beginning say that a form of expression is not merely spoken words or written letters. It could be an action which is taken towards a larger end. For example, a vote given by an individual in an election is his or her form of expression of either approving what the government has done or disapproving what a government has done. Therefore, the living constitutional principle would say that by merely donating money to an organization that criticizes the government would fall definitely in the concept of speech and expression because it is the expression of such an individual towards the action, approving the action done by that organization. To move on and see the law in the United States of America, unlike India, the United States of America does not have a clear demarcation when it was originalist and has moved to being living constitutional. In fact, the United States of America is probably one of the only countries where originalism is still viewed as a completely acceptable means of interpretation. However, that is also in the context of some of its articles which we will look into. There is of course a general view that the United States Supreme Court, which is the final arbiter of constitutional questions in the United States of America, generally moved from being strictly originalist or textualist to a more living constitutional principle after the end of the Depression in the 1930s, when the United States government brought in what was known as the New Deal legislations. Subsequent to this, the United States Supreme Court, through interpretive methods, have brought in newer rights which were till then not vested in its individuals. To give an example, before the New Deal, as in before the 1930s, legislations that segregated white people from black people in public places were held as valid by the United States Supreme Court. It was also valid to have separate schools for non-American children, including children who may have been born in the United States but were of ethnic descent of non-American parents. It was valid for the police to search a vehicle or an individual without a warrant as long as the police suspected that a person was illegally transporting alcohol. It was also permissible for evidence that was improperly or illegally obtained to be used in a criminal trial. To the more liberal-minded person, each of these concepts would appear, if not bizarre, almost abhorrent. But the court in that point of time, holding the fact that the parliament was entitled, the Congress as is used in the United States, was entitled to pass laws to that effect, or that the state governments were entitled to pass laws to that effect, did not hold the same as being unconstitutional. However, after the New Deal, the 1930s, from the 1940s and the 50s, the United States Supreme Court has overruled all of those judgments which I had mentioned above, of segregating whites from blacks, having separate schools, or even using evidence which was illegally obtained. In fact, the United States Supreme Court in the 1960s decriminalized an interracial marriage statute which basically criminalized a white person marrying a black person. It has also said that it would be unconstitutional to have statutes which was targeting people who used to criticize the government. Therefore, the United States Supreme Court, which was largely a court which believed in the procedural due process concept, that a procedure that was established by Parliament would have to be valid and fair, moved on to a more substantive due process concept, much like the Indian Supreme Court, whereby it laid down specific rights in individuals to protect them from state action and also for the benefit of society. The United States Supreme Court, though, is also a proponent of having a unique situation where it has combined the use of originalism and living constitutional principles. This is also because of the nature of one of its rights. The First Amendment of the American Constitution guarantees the freedom of speech and expression. Unlike the Indian Constitution, the American Constitution does not contain any restrictions on the freedom of speech and expression. Therefore, the view could always be that the freedom of speech and expression in the United States is completely absolute and that no form of deterrence or no restriction whatsoever would be acceptable. However, that has not always been the case. The United States Supreme Court has held that it is valid for an individual to burn the flag of the United States of America, since it is an expression of disapproval of the nation's policies. It has even upheld that an inflammatory speech would not be an offence that is punishable, and it has also protected commercial speech, being advertisements or even broadcasts of various corporations. This would seem completely in line with the originalist stand that the First Amendment is absolute and there are no restrictions on it. However, the United States Supreme Court has also held that pornography, and in particular child pornography, is not something that is constitutionally protected. The United States Supreme Court has also imposed restrictions on school speech, meaning things that can be said either through a school or by a student. For example, there has been a case in the United States where a student who approved of drug usage has been held to be a juvenile delinquent and jailed. His petition to negate the action on the ground that his First Amendment permitted him to do the same was not accepted by the United States Supreme Court on the ground that it is a school speech and on which there is necessarily a restriction to be placed. Similarly, the United States Supreme Court has also laid down a principle known as the clear and present danger doctrine, by which free speech can be curtailed and also restricted. From a reading of the text of the First Amendment, nowhere would any of these restrictions come forth. However, the United States Supreme Court has obviously understood that to have speech which is completely unfettered and completely unrestricted would obviously cause problems, has in its wisdom laid down certain guidelines by which it has sought to restrict the manner in which the speech is used, such that the use does not become an abuse. As much as there are supporters of the living constitutional principle, there are those who criticize the living constitutional principle because they believe that it is a form of constitutionalism that is done by the courts, which is a body that is not elected by the people and is not in any manner controlled by the people. They contrast this with a parliament or a congress or a legislature, which is a body elected by the people and which is expected to represent the will of the people. Originalists or textualists argue that if there is a need to amend a constitution or to change constitutional principles, it is a function that must be carried out by the legislature and not by the courts, for this would vest in courts powers which the court is not expected to have and would also cause a constitutional imbalance. The general argument which is used is that using living constitutional principles to interpret the Constitution amounts to a case of judicial overreach, whereby the judiciary enters the field of the parliament and does what the parliament is expected to do. One of the United States Supreme Court Chief Justices, Mr. William Rehnquist, has in fact criticized the living constitutional approach on two grounds. He first says that the living constitutional principle misconceives the nature of a constitution, which is in fact expected to allow popularly elected branches of the government to keep abreast of times and make laws, and also that even though goals that are achieved by these living constitutional principles may be socially desirable, they cannot be accepted simply because it is at the whim and fancy of judges of that particular time. On the other hand, living constitutionalists would hold that the necessity for courts to step in to interpret the Constitution is because the Constitution vests rights in individuals, and the rights of individuals cannot be made stagnant at one point of time, but would have to evolve over periods of time to ensure that they are not infringed or violated by the government. A constitution is not a document which is drafted on an everyday basis. It is a document that is drafted keeping in mind future generations. Having said that, it is drafted at some point of time by individuals who have within their knowledge certain facts and foresee certain other facts, but cannot in any manner foresee all possible events that would occur. A constitution therefore has to succeed itself over generation after generation. For that constitution to be able to do that, the power of the courts to interpret it, to ensure that it does not become a mere document with words written on it, can be done only with the application of the living constitutional principle. However, it should also be kept in mind that if a court excessively begins to interpret a constitution to a point that it begins to act as a legislature, that would cause a constitutional imbalance and may lead to the end of a constitution itself. I hope you have enjoyed this session, and I look forward possibly to having another session with you. Thank you very much.